contravention of its provision. The word liable to penalties denote the civil nature of non-compliances, whereas the word punishable with fine and or imprisonment and or both denotes the criminal nature of non-compliance. It is a simplified research on the basis of the various penalties and fines. The Act clearly lays down the mechanism and the forum for the speedy and smooth administration of judicial activities under the Act. The power of adjudication of civil non-compliances, defaults liable for penalties, is vested with ROC, and power of adjudication of criminal non-compliance, often punishable with fine and imprisonment, is vested with the special court, with sub-delegation of power of compounding of offense to regional director and NCLT. The objective of webinar is to discuss and deliberate the various issues and practical aspects of adjudication, compounding and prosecution under the Companies Act. And friends, we have requested the eminent speaker for today's webinar, those who are doing day and nights of these adjudication, compounding, litigation, and prosecution. So we have eminent speaker for today's webinar, Mr. Amit Gupta, who is a practicing company secretary and insolvency professional and practicing in this area and covering all these aspects. Then we have Mr. G.P. Madan, founder Madan Law Office and M&A Task Force co-chair, associate, and chairman of IBC group of PSD Chamber. He is looking after the prosecution aspects and various practical issues in the court, doing compounding, prosecution, and various other things. Then we have Mr. K.S. Ravichandran, managing partner KSR and Company, company secretary LLP. He is doing so many things relating to this area, and he has immense knowledge of practical aspects of prosecution and compounding. Then we have Ankit Singhi, head corporate affairs and compliances. He is also doing the day and night compounding, compounding prosecutions and the various other adjudication process. Then we have Ravi Prakash, associate partner, securities law and corporate litigation, corporate profession, who is hardcore litigant work doing in the company relating to corporate law. Friends, the structure of the program will be like this. I will start with the framework of dealing with defaults and offense. Then Ankit Singhi will give overview of offense under the Companies Act. Then practical aspects of adjudication, Amit Gupta will share. Then Madan will talk about the practical aspects of compounding. Then practical aspects of prosecution, the K.S. Ravichandran will cover. And litigation aspects of the Companies Act things will cover by Ravi Prakash. Friends, so we will discuss all these issues in this structure. After I'll give my presentation on this particular thing, other people will talk. So friends, when we please go on first slide, Shivam. Friends, as you are aware that overview of structure of offense under the Companies Act. I remember when we were a student and we were always confused with fine and penalty. And then if you see the other laws, there also definition of fine and penalty is different. But when we see the dictionary, then you will not find much difference in this. But Companies Act, in the new Companies Act, when I was talking about the old Companies Act, there was a loosely discussion on various things because whenever the law has changed, they have used the word. And there was non-clarity on various aspects. So what was happening when I was reading as a student, we discussed various aspects, and when I was a committee member of this Companies Act Rules Framing Committee, that time also we discussed and we identified wherever the word, the fine is coming, wherever the word penalty is coming, and whether it's has a different meaning. So I'm just summarizing and giving you how the overview of structure, offense and Companies Act work. So it will be helpful for all the participants as well as the speaker when they will discuss with you. Next slide. So this framework of dealing is number one. These three basic concepts are there. One is liable to penalty, that's number one, or fine and or imprisonment, that is one part. Then we have used compoundable or non-compoundable offense. Then third is cognizable or non-cognizable. Now, what is the meaning of three? Because all three has a different things. So first, very clearly in entire Companies Act 2013, wherever word penalty is coming, this means that this is a default which can be adjudicated in-house. Mechanism like amount of penalty can be adjudicated by ROC. So here this is a penalty mean you pay the fees, fine, you pay the fees and the ROC will do adjudication. Now I have just loosely used you pay fine. So no, penalty is penalty, fine is different. So that is a one difference everybody should understand. So wherever penalty word is coming, it means ROC will adjudicate this. You have no need to go anywhere other place. Then come to wherever word fine is mentioned, fine and imprisonment, fine or imprisonment. Whenever there is word is fine, then fine mean adjudication of fine, imprisonment will be done by the court of competent jurisdiction. So it is not the ROC will do, it is done by NCLT, but some it is done by court. But some power they have delegated, which I will tell you, to the RD and ROC and the NCLT. Next. Now, difference between compoundable and non-compoundable. So friends, that is very simple, but here compoundable mean offense punishable with fine only, with fine or imprisonment or both are compoundable. So wherever the word is fine only mentioned, wherever fine or imprisonment or both is coming, that are compoundable. But where the offense punishable with fine and imprisonment are non-compoundable. So the difference is or. So if there is a word fine and imprisonment, it is non-compoundable. Rest of the thing is compoundable. Next. Now the difference between cognizable and non-cognizable, that is also when we are doing CRPC, we can learn. But here in Companies Act point of view, only one section is cognizable, that is section 447. Any offense which is amount to fraud punishable under section 447 are cognizable offense. Rest of the offense are non-cognizable other than 447. These are the non-cognizable. Next. Now this slide is very important and very simplified, which everybody can understand. Now the entire offense of Companies Act divided into two parts. One is penalty, one is fine and imprisonment. And if you see penalty mean in-house adjudication by ROC. So that is one part, penalty is out. So wherever word penalty, go to ROC and they will put the amount and your work is done. But fine and imprisonment, fine or imprisonment, fine and imprisonment, that word we are finding at so many places. So wherever word fine is coming and wherever word fine or imprisonment is coming, that is compoundable, number one. And if these words are coming, amount of fine up to 25 lakh, RD can do compound. But if the amount is more than 25 lakh, then NCLT will do compounding. So this is the difference everybody should understand. Now next is fine and imprisonment. So if fine and imprisonment word is there and that is a non-compoundable, court will do. But if the offense is cognizable, and that is under section 447 that we know in the Companies Act, only 447 is cognizable offense, that SFIO or court. So court through SFIO or SFIO will file a complaint and then they will. So this is the summary of entire offense in Companies Act 2013, which we should keep this as a record, that otherwise every time we confuse penalty, fine, imprisonment, where to go. So this is the one chart which can helpful to you. You can download this. Next, and the last point, categorization of offense under Companies Act: default, offense, penalty, fine and imprisonment, and no penal provision. Now, it is clear when there is a penalty, respective penalties provided in respective section, that this is the penalty and this amount will be levied. Wherever fine and imprisonment provided in respective section, in which section fine and imprisonment will be there. But there are some violations are there where no penal provision is provided, that under general penal provision under section 450 will applicable. You remember in 1957 Act, majority provision were not prescribed, not penal provision but not prescribed. So that time it was there, always there was a confusion, but in the new Companies Act, it's a very clearly mentioned. So this is the overall structure of offense in Companies Act. Now, this I have given you the overview. Now, I will request Ankit Singhi to just give a detailed one in the Companies Act. What are the section, how it is happening. So everybody should be clear. Then we will come to the practical aspects from Madan, Amit and Ravichandran and Ravi Prakash. In case anybody has any question, please send it to us or write to on the box, and all the learned speaker will give answer. Few questions we have received. Over to you, Ankit.
Sir, I think it will be better since I will be covering all the three aspects in the presentation. Each after I cover one aspect like adjudication, compounding, we can put it open so that we can have a discussion at that point of time only, rather than to come back at the end of the presentation and to relook on those provisions.
Okay, Ankit, then do one thing. You give overview.
Yeah.
So the adjudication issue, Amit will add in this.
Yeah, that's right.
Compounding, Madan will add, and the prosecution, KSR will do, or litigation, Ravi will do. And then we will, if something is missing out, then we'll go back again.
Okay. Good evening, everyone, and wishing you all a very happy and prosperous new year. So I'll be starting with my presentation. It's a brief presentation on the overview. I hope you are able to see my screen.
Yes, you can just do in the slide.
Okay. So, since Sir has already given you an overview in terms of how the offences are categorized under the Companies Act, the Companies Act also prescribes different way of handling different kind of an offence. Like for an offence which is subject to a penal provision where penalty is prescribed, then there is a mechanism of adjudication under the Companies Act. Then there are certain penal provisions where there are fine as a penal provision is prescribed, or imprisonment, or both is prescribed. Then in certain cases the matter can be compounded. And then there are other matters like which are related to fraud, or in most of the cases of fraud there is an imprisonment. All these matters are handled by under the prosecution provisions, while there is under section 212 SFIOs have been granted specific power to file an application for prosecution with special court where they are undertaking investigation. So I will be taking each and every head one by one, and we will put to discussion each and head so that we can have all-round views of everyone on each topic. So starting with adjudication. So section 454 of the Companies Act deals with adjudication. And as opposed to Companies Act 1956, it's a very new concept under the Act, and it's a very useful concept too, if you compare with the other options that are available of compounding or prosecution. So under 454, the government has been authorized to empower officers not below the rank of registrar to act as an adjudicating officer for the purpose of adjudicating penal provisions where penalty as a punishment is prescribed. So under section 454, government by notification has appointed registrar of companies of different registrars in various jurisdictions to act as an adjudicator for the purpose of section 454. Under 454, the ROC, while sending by way of a notice to the respondent, can ask him to show cause why necessary penal provisions shall not be imposed under the relevant provisions if he finds that there is a case of non-compliance or there is a default by the company or the officer in default. In such case, the ROC generally sends a show cause notice to the person, asking them for submitting an explanation to the findings of the registrar of the companies, and thereafter, based on the reply of the respondent and undergoing a hearing process, the registrar decides to adjudicate the matter by way of levying penalty as provided under the relevant provisions. So under this provision also, there is a concept of opportunity of being heard. So before adjudicating any penalty under this section, for any default offense which the registrar feels through, it has to give an opportunity of being heard to the respondent so that they can present their case, and after which the registrar can decide on levying the penalty under the penal provisions. There is also an appeal option available in case the person is aggrieved by an order of ROC with respect to the amount of quantum of penalties imposed. He may prefer an application to the regional director within a period of 60 days. And then the regional director will conduct a proceeding where he will give an opportunity of being heard to both the appellant and the registrar of the companies and hear them, and then pass necessary order confirming, modifying the order which has been passed by the adjudicating authority. The order which has been filed, passed by RD will be the final and binding. There is no other further mechanism provided under the Companies Act with respect to the final order passed by the regional director. I think the only option that is available is to through writ through High Court, where we can file an application for direction to regional director to reconsider or take back the order. So in case of OPC, small companies, startup, producer companies, while adjudicating the penalty, the registrar shall not impose penalties which are more than half of the penalties specified under the relevant provision. So this is a special exemption being given to these set of companies. And now with the definition of small companies being expanded, a large amount of companies will now be falling under the concept of small company. And in their case, in case of adjudication of penalty, the amount shall not be more than half of the penalty specified. So for them and for other these specified class of companies, this becomes much more attractive as opposed to any other mechanism that is available. There is also a provision that specifically in case of non-compliances of annual return or filing of financial statement where there is a default, and if that default is rectified prior to initiation of adjudication proceeding, that, for example, the filings have been done after the due date, but before the initiation of adjudication proceedings by the ROC, or even before the issuing of final order after initiation of the adjudicating proceedings, if the company complies with these requirements, then no adjudication will be required for such cases. So in case of provisions related to annual return and financial statement, once you file them, even after the prescribed period, though there will be a delay in filing, but the ROC will not initiate any action for the adjudication of the default in terms of the delayed filing. So in that case, you will be saved once you file the relevant annual return of financial statement. And that would also be the case even if the adjudication proceedings have been started, but you have not yet filed you have not received the final order of the registrar of the company. So in any case, whenever there will be adjudication proceedings, and if just because of oversight you have not filed annual return and financial statement, you can definitely file the same. So there will be very less chances of any adjudication being taken in this space, specifically with respect to default of annual return financial statement, which is the most common and general defaults where adjudication takes place. So what is the procedure? As I mentioned, the issue there will be issue of show cause notice to the company and officer in default as to why penalty should not be imposed. Timeline will be given for submitting the reply. And then the person will submit a reply either through his representative or through himself. Then there will be a physical hearing at the registrar of the companies. He will fix a date for the hearing and then issue necessary order, the copy of the order to the person and central government, and upload on the website. So once the order is issued, it will be also uploaded on the website. Factors that need to be considered while deciding penalty is the size of the company, nature of the business carried on, injury to public interest, nature of default. There is a specific mention of the penalty being not less than the minimum amount prescribed under the relevant provisions, under the rules, Rule 3 of Adjudication of Penalties, under Companies Adjudication of Penalties Rules 2014. But this we will be discussing how far this is implementable and whether there are chances of or any discretion with the registrar of companies to impose a lesser fee. Fee must be paid through MC portal, and if in case you want to appeal, you have 60 days to appeal to the RD. What are the options available? Okay. Advantages of adjudication of penalties. I think the mechanism is simple, quick, very fast. The long time that is taken by in case of any compounding or court-driven procedure, the time taken in adjudication is very less. Definitely helps in reducing the quantum of compounding applications that are being filed before the RD or the National Company Law Tribunal. And considering that there is also a special provision for small companies, startup, producer companies to have the benefit of adjudication amount being not more than 50% of the amount provided under the relevant provision, then it also becomes much more attractive as a way to get rid of a default, to get it good and move away and initiate, indulge into other key business activities instead of putting your mind on these defaults which keep lingering on for a long period of time. So by going to an adjudication process, you can bring an end to such cases. So some issues under adjudication of penalties provision, whether adjudication application can be filed suo motu. While under the Act or the rules, there is no such provision of suo motu application filing. The rules provides that ROC will issue a show cause notice in case he finds out that there is some defaults in compliance of the provision where the penal provisions provides for levying of penalty. But we have personally handled the case and have also seen other cases where ROCs are also accepting applications filed suo motu for adjudication, where companies after rectifying the default are going suo motu to get the adjudication done, so that in future they don't get any notice of the ROC for any adjudication. So they go on suo motu. So though there is no specific provision, but yes, ROCs do accept voluntary submission of such application. Whether adjudication officer has the power of levy penalty less than what is provided under the relevant provisions. So as I mentioned, the specific section rule, there is no specific case of penalties being levied less than what is there. I'll take Amit's views on what he thinks on this, because this is one of the very the only disadvantageous point in case of an adjudication is the penalty cannot be going beyond the minimum amount of penalty, which in some cases even the minimum amount is also on a higher side. And as a result, we have seen there are a lot of companies and a lot of adjudicating orders are being posted on LinkedIn and other social media where huge amount has been levied as a penal amount for the as a adjudication under section 454. Amit, do you have any views on the same?
Yeah, certainly, Ankit. I think this is one of the most important aspect, and in this regard, I think I'll draw a parallel between the provisions of 454 with Section 15H of the SEBI Act and the judgment of Bhavesh Pabari, which was issued by the Honorable Supreme Court in the year 2020, which was in supersession to the judgment of Roofit Industries. If we just run through what this judgment talks about, I'll just read the relevant part of this judgment, and we will be able to understand how important this judgment is and how it correlates with the provisions of adjudication. Because first we draw the parallel that we talked about section 15A to 15HA of the SEBI Act talks about the penal consequences, and 15J of the SEBI Act gives the power to adjudicate in the similar manner what has now been delegated to the registrar of companies in terms of the provisions of section 454. Now 15J mentions that while adjudging quantum of penalty under section 15I, the adjudicating officer shall have due regard to certain factors, which are like size of the company, repetitive nature, and the damage done by that. If we draw a parallel, then Rule 312 of the Adjudication of Penalties rule provide a similar provision. However, there is a proviso also that is, I think, a root cause of problem for the respective adjudicating officers, which proviso says, provided that in no case the penalty imposed shall be less than the minimum penalty prescribed, if any, under the relevant section of the Act. That is the limiting proviso, which I think causes some challenges to the adjudicating officer. Now, on this 15J, the Honorable Supreme Court 3-member bench overruled its earlier decision of Roofit Industries Limited versus SEBI and provided a controlled discretion to the adjudicating officer in fixing penalties for offences under the SEBI Act as well as SICRA. And adjudicating officer has been mentioned that he shall not be constrained by a minimum extent of penalty laid in the SEBI Act and may, where circumstances so warrant, either waive off the penalty completely or may assign a penalty less than so-called minimum. Therefore, the adjudication of penalty may be expected to be more commensurate with the gravity of offense than was so far possibly, primarily due to the position arising out of the Roofit Industries ruling. So this is the verbatim quote unquote from the judgment of Bhavesh Pabhari. I think this judgment needs to be applied aptly in the case of adjudications also. I personally believe, though why standardization of penalties has been done by the ministry, the attempt was made. Unfortunately, the proviso which was inserted with the objective to standardize has now been interpreted very narrowly by the registrars while doing the adjudication, and they are saying we don't have any powers in this respect. But considering the judgment of Honorable Supreme Court and the spirit of law, and particularly the fact that regional director is not bound by these penalties, whatever are the minimum prescribed penalty. And we have seen n number of order in the last 3 years of time that regional director has been reducing the amount of penalties, whatever the adjudicating authorities have been levying. So I think instead of wasting the time of companies and the litigation, I think a rational, reasonable view can be taken, and the reasonable amount of penalties, that is the Rule 312, may be given effect to while levy of the penalty. That's my submission. I think we can.
But 15H has a specific mention of the penalty cannot be levied less than the amount minimum prescribed
No, it has not.
as provided under the rules.
No, it is not.
It is not. So
that is a distinction point.
There is a basic difference on this.
Yes, because that is a distinction point.
Because the legislature here itself has provided a specific requirement.
While drafting the rules, they have added that proviso. That is the culprit. That is what we have been debating to many adjudicating authorities as well when we are going for adjudication. They are saying that our hands are tight and we are bound by that proviso.
Amit, can ROC or RD on appeal levy penalty which is less than the minimum penalty specified?
Very much. Sir, there are n number of
cases.
N number of instances. Means I'll say invariably in every matter where the unreasonable amount of penalty has been levied. I remember one matter of South where ROC Karnataka has levied 1.5 CR of penalty, which was reduced to substantially very, very less amount, less than 5 lakh rupees in matter of section 42. So it is quite possible, and it has been quite widely prevalent practice, I think, all across.
If I may, thank you so much, Amit sir, for that exposition on penalties and Bhavesh Pabhari's judgment correlated with Roofit. But there is one problem. The problem is that the rule, the limiting proviso that you mentioned, should that not apply to RD, because the appellate authority is also a creature of the statute. It is not a constitutional appellate authority. The appellate authority comes out of the same law, which binds ROC to not levy penalty less than what is prescribed under the Act. And rightly pointed out by Ankit sir, That provision is not in 15H. Or for that matter, when the Rufit judgment was passed, initially, that provision was there by virtue of the 2002 and 2014 amendment, took it away. And therefore, before the matter reached to Bhavesh Pabari, Justice Nariman, Rohinton Fali Nariman, he pronounced in the matter of Siddhant Chaturvedi that the Rufit is a bad law because it allows you to impose penalties mechanically, giving a complete go-by to the rule of disproportionality, the rule of proportionality, excessive and harsh penalty. So I think these are the rules which are at play, exercising which the RD reduces the penalty. But I think there is if at all this matter reaches to litigation, these would be the interesting questions which will be unfolding before the courts.
So Ravi, then one more dimension I think we must discuss. I think that is the fundamental of adjudication. What does the adjudication means? If we can understand the adjudication means to decide what is the offense, whether the offense has been committed or not, and what is the gravity of offense, and decide the amount of penalty. If
Yes.
I am saying the adjudicating officer has not been vested with the power to decide that itself, then itself is a wrong. When you are agreeing that the adjudicating officer has a power to levy no penalty and decide that there is no offense at all in the circumstances, we agree that that power is vested with the adjudicating officer. We can't say that that power is not there. There are many of the matters where the adjudication matter has started and adjudicating officer has levied nil penalty.
Yes.
If nil can be levied, why not the lesser amount of penalty can be levied? That is the question. I think that's a fundamental of adjudication principle. If we take away that power, the adjudicating officer cannot just act mechanically.
But I think there are two different situations in the cases you mentioned. Nil penalty is the case where the adjudicating officer believes that there is no default.
Yes.
Or there are grounds which makes it reasonable to not to impose any fees. And penal provision of imposing of minimum is there where there is a default. The registrar of company is comprehending of the fact that there is a default and he has to levy a penalty. And then, in spite of those factors which are there, the minimum he has to levy is the minimum penalty amount. While deciding on the higher side, he will always be subject to the factors that are outlined in the rules.
Yes.
But a minimum criteria has been laid down by the government, then it should not go beyond the minimum, because in most of the cases, the minimum amount,
while I agree what you are saying
is not in every case the minimum amount is on a higher scale.
No, I agree, completely agree. It has the merits and demerits both. While I agree what you are saying, because it is to put the administrative machinery at a standardization process so that the discretion is ruled out.
Yes.
I remember the situation where even the additional fees at some point of time in the history was levied on the discretion basis. The standardization of the additional fees, what is like 2 times, 3 times, and 12 times, that was not there earlier. It was on the discretion of ROC. ROC used to decide whether penalty of 50 rupees will be there, additional fees of 50 rupee or 100 rupee or 200 rupee. I remember the time. Now, later on,
the courts.
Sorry? Which has been standardized over a period of time just to avoid that administrative discretion, I think. So with that objective they had done, it has a merit and demerits both. If you see merits are like for even all type of companies, you will be levying a standard amount of penalty. So I know in advance what is the quantum of penalty that I'll be levied. Now, there is no corruption involved in that particular levy. But if you see the demerits are if a company is very small and the penalty is very high, maybe company capital is 1 lakh rupees and it is running into losses, the same amount of penalty is being levied. So it may be hard.
Then you will levy the 50%.
Just a minute.
Levy 50%.
No,
because then it would be falling under those criteria.
Maybe I can assume that even then it may be high. I am saying, I am giving you another scenario. Maybe company is very big and the quantum of penalty what is prescribed by the government also, even in proportion to the harm that that particular offense has done, is very high, is very, very less rather. In that case, it encourages the companies and the officers to continue with the offense, because if you weigh between the non-compliance cost vis-a-vis benefits of non-compliance, I think the benefits are far more. The peoples and the industry will be encouraged to go for non-compliance. My point is that that must also be considered while debating on the adjudication.
Okay. So whether order of RD with respect to appeal filed against the order of adjudicating officer can be challenged. So if we don't agree with the order of the RD,
no provision for challenge is there
under the Companies Act.
I had been discussing this issue with Ravichandran sir also, and we have a benefit that we can take his views also again. I had read one fundamental principle, and that fundamental principle is that there should be two levels of appellate mechanism for any of the judicial process, whether it is administrative or otherwise. If you see, district court has the appeal level, then everywhere in NCLT also you have an NCLAT, then you have a Supreme Court. DRT, you have a DRAT, then you have a Supreme Court, right? All channels have the two level of appellate mechanism. Why in the adjudicating mechanism we have only one level of appellate mechanism? Why not we have a two level of appellate mechanism? That is the question which you are flagging before all of us. So definitely there is
is to file a writ.
Yeah, writ is in any case a constitutional remedy. That is not the
That's the only
appeal.
option available.
Yeah, that is not the appeal. That
No,
is,
so just the point was the aggrieved can use that option
correct.
in order to get a remedy.
And that's true if your constitutional wires are being touched upon. If they are infringed, then only you can invoke the provisions of writ jurisdiction. Otherwise, may not be possible at all the times.
I will just add, although I in principally agree with sir, the question of wires is just one aspect of Article 226, because it is now no more a res integra, not an unsettled law, that the powers under Article 226 of the High Courts are plenary powers. They are not similar to Article 32 powers of Supreme Court, which are only for fundamental rights. So any right which is also a subset of the constitutional right, or it suffers from manifest arbitrariness, or if it is an error in the law, that can also go to High Court. So if the RD does not apply the principles of law or falls foul of the provisions of the Act, the writ lies.
Yeah, that we have seen in many of the cases, like disqualification of directors matter, 264 and 267. There have been n number of writ petitions, and that has been on the that particular ground only.
Yes.
I think Madan Saab was saying something.
Amit, do you remember in how many sections under the Companies Act there is a provision that penalty which shall not be less than this amount is prescribed?
Yes.
Barring couple of sections, in all the sections, this fixed penalty has been mentioned.
Prescribed,
there is no question of minimum or maximum. Now this entire legislation talks about imposing of penalty which is fixed in nature. And then it talks about factors to be considered while imposing a penalty. I think whatever has been provided in the rules, no doubt it can be said that it has been provided by way of a clarification. But I will say that rules cannot override the main body of the legislation. If main body of the legislation talks about penalty which is fixed, and then the factors to be considered while imposing a penalty, I think the rules cannot override the main right. And in all fairness, the adjudicating authority and, as Ravi said, appellate authority, both in my view are having power to impose penalty less than the penalty prescribed in the legislation. Otherwise, a person like me will always go to a High Court and file a writ petition and challenge this imposition of penalty, which is a fixed one.
So only one submission or supplement to what you have been mentioning, because if we read the law very closely, the Rule 312 and the other related provision, it all binds the adjudicating authority. It does not bind the appellate authority, that is the regional director. Somewhere from there, this interpretation is coming, and the regional directors have also got convinced with this particular view, and they have been reducing the amount of penalties. Now, as you mentioned rightly, that there are different type of provision. If we understand, there are primarily 4 type of penal consequences which had been provided. One, where the fixed amount of penalty has, that every officer of the company or the company will be punishable with the penalty of rupees 5 lakh. That is a fixed amount of penalty. There is another provision where the range has been provided, that a fixed amount of penalty and then additional penalty for each day of default. In both of these cases, it is a fixed amount of penalty. If we go with the strict interpretation, I think adjudicating authority has got no jurisdiction to reduce the quantum of penalty. If we go literally with the proviso, what we have just talked about. Now, there is a third case. Third case says minimum amount of penalty of rupees, let's say 25,000, which can go up to 5 lakh rupees. Now, here the range has been provided that 25,000 is a minimum. ROC can levy the penalty between the 25,000 to 5 lakh rupees. That is the third category.
I think the rule should apply only is in third scenario, not in the first and second.
Absolutely, that is what the ROC has been doing. Very few scenarios are there where the minimum amount has been minimum and the maximum amount range has been provided. Very, very few cases are there. And in those cases, adjudications order I have been privy to review, and those cases the discretion has also been used by the ROC. So to some extent ROC is right, but I think a corrective course is required to be decided by the ministry to take it forward. I'll just add one more because we have a
just a minute. So can we say that wherever a fixed amount of penalty has been prescribed, the hands of ROC are not tied up, and ROC may levy a penalty less than the penalty prescribed under the law?
No, that's where the difficulty is. That is the view that we have to emerge or we have to generate, because if we go with the strict interpretation where the fixed amount of penalty is there, proviso will come into picture. Unless we apply the Bhavesh Pabari analogy, will be tight in the hands and will not be able to give the discretion to the ROC.
Sir, but in that case, the rule is obsolete in all the sense, because neither the factors are important to be considered, and then neither the minimum amount concept is there, because there is one single amount.
Absolutely.
I think the concept of minimum amount is only there where ROC has a choice between A to Z, and then government is saying that, okay, you have a choice A to Z, you cannot go beyond A. But where you have only choice of Z, then you can apply the rule which is given under the rules, the factors which are given, then adjudicate accordingly.
If I can sum up, so you can say the Rule 312, which provides the grounds on which the penalty can vary, will apply only in those cases where the range has been provided. That is the minimum amount of 25,000, maximum amount of 5 lakhs. So now you have a range in which the ROC has a discretion. Now in rest all cases, the proviso will supersede. That's how the interpretation should go. If we talk as an academician, as a student of law.
But in that case, then it defeats the entire objective.
I agree, but then
there is no case of any even hearing to. You can just send a notice of adjudicating.
I believe, Ankit, if you remember, I think we are already delayed in implementation of the e-adjudication. What ministry was supposed to implement from April 1, 2022. I think now they are all set to implement from April 1, 2023. That e-adjudication will start. The moment you file the form, the alert will come that it seems that you are filing the form with a delay, and it attracts the adjudication provisions under 454. And immediately e-notice will come on your inbox. And it will give you the opportunity, and after a couple of formalities in 15-30 days of time, the amount of adjudication penalty will also be decided electronically itself, and that will be, you will be directed to like faceless assessment. A similar kind of mechanism is going to be rolled out. That's what the intention is.
But in such cases, is there any room for ROC to not to levy any fees where there is a minimum amount is prescribed that the fee is 5 lakh has to be is the penalty amount?
Ankit,
and there is a default.
I don't think intention of ministry is to give any discretion. Ministry wants discretion to be removed. Now, so they want a fixed amount of regime to begin, irrespective whether you are small, whether you are big. But I am only highlighting to the regulators that we must consider the danger of the provision that a fixed amount of penalty can give is that if a cost of non-compliance vis-a-vis benefit of non-compliance has to be evaluated, then in many of the cases it might give encouragement to the corporate houses to go for non-compliance.
But I think once with this process becomes automated, then the difference between cost of compliance and cost of non-compliance will not be there, because then as and when you are doing the non-compliance, you're immediately getting the notice. The problem today is that you do the non-compliance, you don't get the notice. It takes 2 years, 3 years, or even you will never receive a notice.
No. Ankit, I'm not on that point. I'm saying ki I know that maximum cost of non-compliance is, let's say, 5 lakh rupees. And the benefit which I can get out of non-compliance is, let's say, 100 crore. I'm ready to take a non-compliance because I know it is no longer a criminal offense. I will not go behind bar. Maximum downside is I'll be required to pay 5 lakh, 10 lakh, 20 lakh rupees of fine. That's it.
But I think, sir, then that will be in all the cases. Even you go for compounding or everything. In this would, if this would be the criteria, then in everywhere there is only a fine, you will always escape by paying that fine getting the benefit.
I completely agree. And that's the way the ministry has. I think that's a very important takeaway for all the participants to understand what is the changing dynamics. I think government has very consciously shifted the criminal liability to a civil liability very smartly, because under 1956 law, as Pawan sir was mentioning, all the offences were criminal in nature and none of the offence was civil in nature. There was no concept of civil adjudication under the provisions of the Companies Act. It is only Companies Act 2013 which has inserted the provisions of section 454 by which the adjudication concept has been inserted. Reason is because government knows the shortcomings of their criminal procedure. It takes years after year. I still remember in 2000 I started practice. Many of the matters which were initiated in 2002 are still before the court of law, in criminal court. It still means 18-20 years after the matters are ongoing. So government very well know the deficiencies of their own system. They know we will not be able to complete the prosecution. They shifted the gear. They said, let's make everything adjudicatable except those which are fraud in nature. So I am believing that in times to come, only the fraud related offences will remain criminal. Rest all will come in the jurisdiction of adjudication.
I mean,
So,
that should be the aim of law also. Now today, when we have seen that matter has gone to the standing committee, you can see the government is also planning to do the same way. They are not only in company law, they are removing from all other places.
Yeah.
The Jan Vishwas Amendment Provision Bill they have brought out, that is talking about the various law, and that should be the thing. Otherwise, what was happening earlier, you are right, there are thousands of cases are filed in the criminal court and various court in the country, and that is still going on, and there's no fate on this.
No, I completely agree, sir. I'm only cautioning with the one danger of divergence of criminal liability to a civil liability. One shortcoming which I want to flag before the regulator, which must be considered going forward, otherwise we might end up going in a wrong direction completely. And that is the point which I have highlighted, that because in criminal offense, there is the opportunity of trial. And in trial, if you have not done any offense, you might not be levied any fine at all. And if you have levied, then you may be put to behind the bars also. So that is the risk that you have in the case of criminal offense. But there is no such risk involved in the case of civil adjudication. I know what is the maximum downside. That's the caution that the government has to take so that we should not end up in making a provision which takes away all the teeth of prosecution from the government.
But
Maybe
we are moving to an American style of legal system.
Correct,
No? Where
correct,
for
correct.
most of the cases, you pay fine and you can escape out of it. Just pay fine.
Correct.
So next is
You
in
know-
case of appeal, RD can reduce the quantum.
I
Yes,
think
sir. Madam, sir.
This decriminalization or more of adjudication is a double-edged sword. As Amit said very rightly, on the one, there are two schools of thoughts on this. One school is very happy. Let's do anything and everything. Nothing is going to happen. We'll pay simple penalties and we'll come out of the clutches of this entire prosecution. Another school of thought is that it may lead to more and more corruption. I don't know whether it is right to say on this platform or not, but all of us know it very well that what exactly is the adjudication process. Is it right? Are we giving judicial powers to the bureaucrats? As Amit said very rightly, a trial has to happen. But in this case, there is no trial. I think the rules of the game have to be laid down by the government while decriminalizing these offences. Some people who are there at the helm of affairs or who are acting as adjudicating authority should have judicial bent of mind before they adjudicate these offences and levy the penalties. And those precautions and cautions have to be taken. This is what my take is.
Anyway, now, Ankit.
So next is we already important question, sir, where provisions have changed from compounding to penalty in a lot of places. And some offences were committed at the time when the provisions was subject to fine, and now it is a penal provision subject to penalties. So if you want to get it good, what is the best way? We have to file the compounding application or adjudication. So did you get the question?
Yeah, very well. I think on 1st of November 2018, the non-filing of annual return and balance sheet was decriminalized.
Yes.
Now, question is that prior to that, if I have not filed the balance sheet for the year, let's say 2017, and the due date was 30th of October 2017, the offense at the time when it occurred, it was a criminal offense. Ideally, the matter should have been filed before the special court for being tried before the judicial authorities. Now, it has not happened. Today, if I want to buy the peace of mind, should I go for compounding or should I go for adjudication? That is question number one from the company perspective. Let us see it from the regulator perspective also. Now, today, regulator wants to start the prosecution. Should it go for filing a case before a special court or should it start the adjudication? Because at that time, so whether you have to see the offense at the time or the punishment at the time of commission of the offense or at the time of start of the prosecution is a real question that Ankit has asked. I think very valid question. And
so while we have handled some cases where we have gone for compounding and RD has
views are there. I have both.
In some cases, we have even filed for adjudication considering the current provision just to see what how the view is taken. In those cases, ROC has returned the application with a order that you need to file it for compounding, considering the penal provisions at the time of the committing of the alleged default was subject to fine and it was compoundable at that point of time. Since the penal provisions are governed at the time of the commission of the offense, the remedy will also be applied, which was available at the time of commission of offense.
So that means, sorry, sir. Just a minute. So that means you are saying ki all offences which have been committed prior to 1/11/2018, especially in respect of non-filing of balance sheet and the annual return, and the 16 other offences, Ministry has only option to file a case before the special court. They cannot adjudicate simply.
Yes, this is what they are doing. But I believe there are certain judgments, not on the Companies Act side, but on in the other laws, where courts have taken a liberal view and have considered the liberal penalty at the time of filing the application and have adjudicated on that behalf itself. But this is what we have understood from the practical aspects of dealing with both the RD and ROC, that they are only considering the applications on these premises only, that if it's commissioned at the time when the offense was subject to fine, it has to be filed through compounding route. And if it is committed at the time when the offense was subject to penalty, it has to be filed through an adjudicating route. You cannot file a compounding application today in form of an adjudicating application.
Ankit, there has been a judgment of Madras High Court under Companies Act itself, dated 26th of May 2022, which says that penalties or the punishment as provided in the law at the time of commission of the offence shall be applicable.
That is what I'm saying.
Not at the time of imposition of punishment.
Yeah, so that is what I'm saying.
Yeah.
Yeah, Ravi.
Yes, but I just want to extrapolate the different aspect of this very matter. We are discussing that when a time in past, a penalty was provided and the penalty was in the nature of imprisonment, let's suppose. But in subsequent amendment,
Ravi, let's not call it penalty, let's call it punishment.
Punishment. So, yeah. Thank you, sir. So the punishment was provided, but by virtue of subsequent amendment, the punishment was reduced or say removed. There is a judgment of Supreme Court and it has been consistently followed. It is called T. Barai versus Henry A. O. It's of 1982 and it says about beneficent construction. So the rule is what Madan sir and Amit sir has told, that the penalty or the punishment should be as per the law applicable of the time, the corresponding law. But the converse of the principle is also in the jurisprudence, which says that if the law subsequently reduces the rigor of the punishment provision, you should give the benefit of that provision. So the reduced punishment must be applicable. And that has been consistently held in Food Adulteration Act, in other acts where the corporates are involved. So that has been consistently applied.
Yeah, I was about to quote that only, and we have got one adjudication also done on this premise only. In respect of 2015 to 2017 non-compliance. It has been adjudicated, and it has been adjudicated on this premise only, that the beneficial construction will be applicable and the benefit will be available to the corporate.
Yes. So you have tested it already.
So, yeah, please go ahead. Okay.
So moving on to the next point is with respect to the compounding of offences under the Companies Act. So the basic difference from adjudication and compounding is the term, that is the penalty and the fine. While all penal provisions which are punishable by penalty is subject to adjudication, and others which are punishable by way of fine are subject to compounding, subject to meeting of certain conditions. So compounding is a way of settling the offence, where you can avoid prosecution by way of paying a requisite fine and filing an application. Similar to a concerned mechanism that is available in case of SEBI, compounding mechanism is available under the Companies Act. See, authority of compounding is NCLT and regional director. While regional director can do compounding up to an amount of 25 lakhs, where the fine is not exceeding 25 lakhs. Beyond that, or even less than that, can also be handled by the NCLT. So there are a lot of doubts whether the NCLT can only handle compounding of an offence which is more than 25 lakhs. While this is generally a tradition and ROCs do follow this, but there has been a judgment by NCLT in year 2018, where they have held that the amount criteria, the pecuniary jurisdiction is only provided for the regional director and not for the National Company Law Tribunal. So they can even adjudicate on matters which are less than 25 lakhs in case the application is filed with them. If an offense cannot be compounded, if the investigation is pending against the company, we need to consider an important point, the difference between investigation or inspection. So while section 206 to 20, I believe 10 or 9, they deals with inspection or inquiry, where the process is undertaken by either the regional director or the registrar of the companies. And then there are provisions with respect to investigation under section 211, 212, 213, where there are investigation by the government, investigation by the SFIO, investigation in the ownership of the companies. So these are matters which are related to investigation. So if any matter of investigation is pending under any of the relevant section at the time of filing the compounding application, then you cannot file that application for compounding. The officer will not get it adjudicated, considering the investigation is ongoing. First, you have to wait for the completion of the investigation, and only thereafter you can file an application for compounding. Similar offense cannot be compounded only once in 3 years. If you have compounded one offense today, you cannot compound this offense for next 3 years. But if you have not compounded, if you have defaulted on a similar offense during last 3 years, you can definitely file a single application for getting compounded all the offenses for all the 3 years, since you have not yet compounded offense for any of the year. So you can file a single application where you can seek prayer for compounding of offenses which were done in each year for which the application has been filed. So compounding can be initiated both either at the time of filing the prosecution or before the filing of prosecution. So if it is filed before the filing of prosecution, then once the compounding is done, necessary orders are filed with the government, the prosecution is not initiated. In case the prosecution is initiated, then you can also file the compounding application, give necessary intimation to the court, and necessary due course will be followed once the matter is compounded.
Ankit, I think there is one very important point that you have highlighted regarding the time lag, that if an offense has been compounded, then the minimum period of 3 years has to elapse. I think we need to elaborate a bit more with an example. I think, let's say,
because there are a lot of combinations that can happen with respect to the company officer and default.
Yes, there is a consistent query from the professionals in this particular regard, that let's say offense was committed for the non-filing of balance sheet for 2015, 16, 16, 17 and 17, 18. And compounding application has been made, let's say, for 2015, 16. And the offense has also been compounded. Let's say order was passed on 31st of March, 2019. Now, company has got the offense for 18, 19 also. So there was earlier offense for 15, 16, 16, 17 and 17, 18. Order came on 31st March 2019 for 15, 16 non-compliance. Now, whether company can go and get the offense compounded for the financial year 18, 19.
First of all, Amit, may I ask you that when this compounding application was filed?
It was filed in the year 2017. Okay. 17, 18, let's say.
No, 17, 18, that's important, because if by that time, if there was a violation of 2 consecutive years, then as Ankit said, that application, compounding application should have been filed for both the years. One single application should have been filed for both the years.
That was a choice available.
So they didn't file it for all the years. They filed it only for 1 year.
They filed it for 1 year.
The objective of this 3 years gap is to stop repeat offenders. So once an offense has been committed, you get that compounded, you should not be repeating that offense again.
Yes, so I think
in this case, since the offense was already committed before the filing of the compounding, and for a year which is different, I think that it should go through generally.
Yes, absolutely. That is what the distinction is, because after getting the order of compounding, you have a cooling period of 3 years.
From the date of the order.
From the date of the order.
Date of the order.
The date of. That's most
irrespective when the application was made, whether the application was made in 15, 16, 17. I think that's the point we all need to understand, how the regulator is or the NCLT is or the regional director is looking into the non-compoundability in the block of 3 years period.
It means in your example, the compounding application for 16, 17 and 17, 18 can also be filed now, and that shall be considered and entertained.
Yes, absolutely. One more distinction, which is the distinction between the adjudication and compounding. Whereas 3-year block period, cooling period is applicable only for compounding. There is no restriction in respect of adjudication. You did like in present time 21-22, it is a adjudicatable offense. You went to adjudication, your application for adjudication has been accepted. Now in 22-23, again you committed the same offense, you can still be adjudicated. There is no restriction. That's a distinction between the adjudication and the compounding. And one more point I think you mentioned in the beginning itself, can we go for suo motu adjudication? Though we can definitely file the application, but let us understand for a larger benefit, why one would like to go for adjudication. Adjudication means I am admitting that I have committed an offense. Why I want to make a self goal? What is the advantage that I want to gain out of doing the adjudication? I have no advantage. In case of compounding, allow me just a minute. In case of compounding, because criminality is involved and you are going for doing a barter in respect of that, by paying some additional cost, the criminal prosecution will not be initiated. That is the barter that I am doing with the regulator, that you please don't initiate the criminal prosecution in future. I am ready to pay the cost. That is the compounding principle, right? But in case of adjudication, there is no criminality involved because the offense is civil only.
I don't think it is always about the criminality.
But on the contrary,
just a minute. So what I am saying, in case of adjudication, let's say I have not filed the balance sheet. I have filed the balance sheet with a delay of, let's say, 300 days. Whether I go for adjudication today or after ROC initiates the action, my amount of adjudication is remaining same. It does not vary because after 300 days, the offense has been stopped. And each day, if let's say 100 rupee penalty is prescribed, for 300 days into 100 will be the maximum penalty which can be levied. That can be levied today also, or maybe 2 years after also. So I don't advise, a lot of law firms are advising you go for suo motu adjudication. You do the self goal. That's how you are coming to know that company has not complied with the provisions of secretarial standard and the adjudication orders are visible on the ROC portal. I
don't think it would be called as a self goal, because a lot of companies are very vigilant in terms of compliance and they take it very, they consider it as an important part of the working. So they themselves, if there is a default, they want to make it, make what are the mechanisms which is available. Sir, it's not, because it's not always about self goal. Even in compounding, a lot of companies go for self compounding. A lot of companies even wait. Let's see, whenever the ROC will issue a show cause, we'll go for compounding at that point.
In compounding, there is a justification because you are avoiding the criminality of the prosecution. But
there are a lot of offenses which are just payable by fine. The only they are avoiding is the following up with the code.
But still, because it has the criminal consequences, because the disqualification and other things can happen. So
not with the case of balance sheet, because there is lesser education.
If I may chip in, just a short point. In SEBI law also, just to rationalize this, in SEBI law also, there are a lot of provisions under which penalties are only imposable, or they can be imposed, only penalties. But there is a facility of settlement and there is a facility of suo motu settlement. So even in case of penalties, because so it's a case of plea bargaining. You go to suo motu before the regulator and you get a discounting factor. Although there is no such discounting factor under the Companies Act, they may think of bringing out a settlement regulation, a separate set of it.
That's what the
point is. But at times, I think both RD and ROC consider this favorably if you are filing it suo moto.
Certainly,
and that
because
has definitely a bearing at the time of adjudicating
yes,
of
the answer lies.
fine or the compound. And if in most of the cases, we also raise this point as part of the application.
Yes.
And then it is filed on a suo moto basis, so you need to consider it favorably.
No, the point is that are you getting any benefit out of it? Are you getting
it's
any
not
discount?
about the benefit. I think it's always also about the attitude and culture of any company. A lot of MNCs go through this. They even get it compounding, as you mentioned, for non-compliance of secretarial standard, which is very peculiar matter. But this is the way. There are corporates which do work like this.
There is another important aspect. The question whether the suo moto factor should be given benefit to arises out of the initial discussion, or say I would say the prefatory submissions made by Gupta sir. That the Bhavesh Pawari judgment also says that the 15J, to which the provision under company law is akin, is not on. It is non-exhaustive. It is an indicative provision. There could be certain other mitigating factors which the adjudicating officer can take into account. And suo moto application is certainly a mitigating factor. It must be taken into account and must be qualitatively as well as quantitatively, both ways. It can be taken into account.
So a takeaway, I completely agree that there is no harm, but what I am trying to draw attention for the regulator is a scheme which is akin to a settlement scheme in the case of SEBI law can be introduced for the suo moto adjudication in case of Companies Act also, which can be given certain discount and the other factors. So there will be a lot of encouragement also, and it will be a lot of revenue collection for the government also. As far as
in terms of filing, they do bring it from time to time, but not for other defaults.
Not for this.
Filing,
Yeah,
they do bring it from time to time. So application process is very similar to ROC. Adjudication, you file it to ROC. ROC considers the amount, the quantum of offense that is involved. Forward is to the RD or the NCLT. One point important to note that the quantum is determined per applicant and it is not aggregated, and then it is determined whether it needs to be filed with the RD or with the NCLT. So if your offense is 5 lakh rupees per applicant, the maximum amount, then there are 5 people, they will not be, or 6 people, it not be aggregated to 30, and then it will go to NCLT, because the offense has to be, amount has to be calculated for each applicant. So if there is an applicant which is only furnishable with a fine up to 5 lakh rupees, and even there are 6 or 10 in the same application, it will go to the RD. Then RD and NCLT will they generally scrutinize the application, raise queries if there are any, and then give the date of hearing. On the hearing, the compounding order is given. In many cases, I've seen even without a hearing, there is a compounding order where parties are not willing to attend. Then our RDs are also filing ex parte order with respect to compounding. And then thereafter, once you receive the compounding order, you pay the compounding fees on MCA portal and find relevant INC 28 in order to settle that case. In case the prosecution is filed, then in the relevant hearing, RSV will bring this to the notice, or you can also bring this to the notice of the court that the matter has been compounded. In case you bring it as notice to the court, the court will always checks it with the lawyer representing the ROC, whether it's been done or not. And if it's settled from both the ways, then the order is passed and the case is closed in case of prosecution. Under the Companies Act, whether the Act bars filing of joint application for a defaulting company and officer in default, yes, you can file application together or individually. Even some officer in default can file their application for compounding. Even the compounding company can also file an application for only compounding the offenses for which it is liable. So it can work in any permutation and combination. There is no bar. Bars filing of joint application for compounding of same offenses committed at different years. As per the NCLT order, there is also no bar if there is an offense which has been committed at different year. Though the cooling period is not a hindrance, you can still file a common application for all those years in a single application. As I mentioned, for 3 years, you're not been doing certain filings and it is compoundable, you can file a single application for all those 3 years. Tribunal has jurisdiction to compound offenses where prescribed is less than monetary jurisdiction. As I mentioned in the initial discussion, yes, they can undertake such kind of application. But in most of the cases, since the application is routed through ROC generally tends to always follow the pecuniary jurisdiction, and all 25 lakh rupees fines are routed through RD and not through NCLT. How to quantify? I've already discussed. Whether officer in default can escape prosecution without applying for compounding, mainly on the ground that company has obtained an order for compounding. We need to understand that both company and officer in default are liable individually. So if one gets compounded, even one officer in default gets its offense compounded, it doesn't gives any leeway or escape route to the other offenders. And similarly, if company gets the offense compounded, the officer in default continues to be liable for getting it compounded. And in case the compounding is not done, ROC may initiate prosecution against those. Whether making good the default before filing a compounding application is mandatory. So this is where I'm seeing a lot of discretionary practices at different RDs. While some RDs specifically ask for you to make the offense good as a part of the compounding application before you adjudicate. There are RDs which also don't put this as a mandatory condition. Even if you see section 441, I don't remember the exact subsection, there is a specific subsection where it says that in case of defaults with respect to filing and certain other things, the RD while compounding or NCLT while compounding the offense can direct the respondent to undertake the respective filing or undertake the respective compliance. So this makes it more curious that whether compounding is a precondition or not.
No,
sorry, making good default.
Certainly it is not. If you see, as you rightly mentioned, there is no provision in the law which mandates that making offense good is a precondition. You were talking about section 441(4) perhaps, which talks about that RD while passing such order can make insistence that you will make compliance of that particular provision. That's it. That's the only point from where you can get some clue, and invariably the orders are being passed only after you make the offense good. But there are certain situations where you are not able to make the offense good at all.
Not possible.
Not possible, right? So if that is the case, let's say you have not complied with the provision of accounting standard while preparing a financial statement, right? Now, if you go for reopening of the account and the other thing, I think it will open up another Pandora box, and it will be altogether a different provision under 131, and then you will be able to comply with the same. So, but still the offenses are being compounded on the undertaking that you will take adequate care in the future. So it's nowhere mentioned, and it is not necessary that making offense good is a precondition. But yes, wherever it is possible, the RDs are insisting that you should make the offense good.
Whether compounding amounts to relief from other consequences? Yes, so far as prosecution is concerned under the Companies Act, once you get the matter compounded, you are free from any further prosecution under the Companies Act. If similar default has consequences in any other law, and you have admitted that default as part of the compounding, then you will not get any remedy from those laws. The legal recourse have to be taken under those respective acts.
Yeah, example is, let's say a director has violated the provisions of section 184 with regard to disclosure of interest, right? He will vacate. Now, if you have done the compounding for a particular provision, that non-disclosure of interest, that is for 184, whether you will get automatic remedy under 167 also, that is not true. Even if your offense is compounded, your action, the consequential action under 167, that is the vacation of office, will continue. I think that is what you intended.
Yeah. So another important question is that while there is a specific definition of officer in default under the Companies Act, and it lays out the persons who will be treated as an officer in default, and a general interpretation and understanding is that wherever there are executive directors, non-executive directors are not liable as officer in default. But we have been continuously seeing that while issuing show cause notices, ROCs have been marking the show cause notices to all the directors, in spite of the fact that there is a specific circular of MCA in March 2020 where they have specifically asked officers to be careful while sending notices to non-executive directors, unless and until there are circumstances which very clearly establishes that they are involved in that offense, and they don't have the remedy available under section 149 subsection 12. But in spite of the fact, we continue to see a lot of NADs receive those notices, and even I've seen a lot of NADs that prosecution is also filed, and we ourselves are handling such cases where prosecutions have been filed, irrespective of the fact that that concerned person was an NAD at that point of time. So in this case, the general advice we generally give to the companies is to bring this point to the notice of the ROC, even if you're going for a compounding for officer in default. In the compounding order, we pray for a remedy that the other directors who were marked the show cause notice and who were not officer in default under section 2 clause 60, there should not be any adverse action be taken by the registrar of companies against them. There is no other way you can escape this. If the case is filed before the court, then you have to fight it out there only.
Ankit, I think you have raised a very, very interesting aspect now, because the adjudications have started and it is more visible in case of adjudications, right? Because let's say the company has 5 directors and all are, let's say, whole-time directors, or 4 of them are whole-time directors. So automatically, by virtue of 2 clause 60, they become the officer in default. So all the 4 persons become liable to the penal consequences as per the respective provisions of the law. Now, to avoid such kind of situations, I think it becomes all the more important that the company should fix up the liability and appoint a particular person officer in default for a respective compliance. So it will reduce the quantum of penalty if at all that occurs in future. What is the provision? You have to invoke the provisions of respective section, and GNL 3 form has to be filed in respect of particular delegation of power or particular assigning a responsibility. Let's say for the Companies Act compliances, there is a company secretary who has been nominated for the purpose, and or there is a particular executive director or managing director. Then in case the non-compliance occurs, though there are 4 executive directors, the officer in default would be only 1, and that particular person will be qualified for the purpose of levy of the penalty. Now, I have one more interesting scenario while going through a couple of orders of adjudicating authority. There is one case where, if I remember the name, that is Angla Enterprises Limited, and wherein the default was in respect of section 203, that is non-appointment of a company secretary. And interestingly, the submission that was made before the adjudicating authority, rather not before the adjudicating authority, but before the regional director, while appellate in jurisdiction was invoked, the company took a stand that we have nominated one of the whole-time director as a person responsible for identifying a suitable company secretary for the company. So he should be only considered as an officer in default. And even after asking inquiry by the RD, they have filed form GNL 3 after that. I still remember distinctly the date. There is a difference of almost a month. The notice was issued on October month, and the form GNL 3 was filed in the month of November. Despite of that, the RD has taken into that particular form in cognizance, and they have levied a penalty only for one particular person. I think an important takeaway is to use the provision of officer in default wherever it is possible, so that the liability can be reduced. Now, I have one more aspect which I want to deal with and take the view of the others also. Let's say there is a case of non-compliance of non-convening of meeting in time. Like we are required to convene the meeting within 120 days so that the gap is not more than 120 days between the 2 meetings. And I have generally what happens in the case of secretarial standard also, there is a provision that I can nominate one of the director or person for the purpose of convening or the issue of the meeting. Though I have not filed any GNL 3. Will I be able to make a case before the ROC that because I have delegated the power by virtue of a board resolution in favor of one particular person and he has failed to convene a meeting, and the penal consequences should be limited to that particular fellow only? Will that fly? I want to take a view of this panel.
I think Ravi Chandran has joined, so Ravi can give his view on this. Or Madan, anybody can do this. Yeah, Kesar?
Amit, can you please repeat it?
Sir,
I think when Amit is there.
Amit and Ankit, we have received 35 questions.
And Amit is there, nobody else can speak, you know.
No,
No, because 35 questions are there. We have to reply everything. So we have to be very, very
Yeah,
sure.
I'll wind it up shortly.
Yeah, immediately do it and then question answer.
we can park this issue and I think we can discuss it at once we have a question answer.
I need a couple of minutes on this. You know, as a lawyer, I feel more comfortable in compounding rather than adjudication. According to me, compounding is more convenient than adjudication. Number one. In case of adjudication, what is levied is penalty. While in case of compounding, what is levied? Fee.
Cost.
Compounding fee, you know, and tomorrow if you are filing any form, and if the question is there whether any fine or penalty has been levied against you under Companies Act, if it is adjudication, you will say yes. But if it's compounding, you will say comfortably will say no. So from that angle also, I feel more comfortable, and according to the compounding fee is always much lesser than the adjudication.
Yeah, discretion is higher on that side.
Then secondly, you were discussing about this penalty of non-executive directors, liability of non-executive directors. I think we must always consider this circular, MCA circular of 2nd of March 2020. And in addition to that, in the year 2021, there have been two judgments from the Supreme Court. One is in the case of Dale D'Souza versus Government of India, and another was Ravindranath Bajpayee versus Mangalore Special Economic Zone. In both the cases, it has been decided by Honorable Supreme Court that no action should be taken, no criminal prosecution should be launched against the directors, non-executive directors, independent directors, manager, or even on secretary, unless you are sure that there is a direct involvement of these individuals and they have given their consent, or the offense has been committed with their knowledge. Otherwise, no criminal prosecution can be initiated against them. So those two judgments of Supreme Court actually are very, very handy for everybody. And the third, with respect to this officer in default, I'm of the view, and I give this suggestion to my clients also. Nowadays, you have as many KMPs as you can. Now, the KMP is not confined to 3 only. You designate every HOD, every departmental head, every project head as KMP. The moment is KMP, he will become officer in default automatically. So in case of any non-compliance with respect to that particular department or division, not under company law, but under any other law also, I think you have an officer in default. Readily available, very, very handy. And this works for both, you know, for a company, the board, as well as for the individual concerned. The individual concerned feels more comfortable, rather he is more very, very happy that today my board has designated me as KMP of the company. And on the other hand, if you ask the board of members, unhe lagta hai bali ka bakra mil gaya aaj hame. Now we have somebody who has been designated KMP and who will be officer in default, and he'll be very, very careful in discharging the functions of this particular department. And the ultimate impact of this is, I tell you, that the compliance level of that particular department or division will go up. Because now this individual will be very, very careful regarding compliances of the provisions of not only company law, but all the laws. Now, let's welcome Mr. KSR.
I think he has joined.
You can finish
Yes,
off.
sir.
I think by the time his audio issue is there, I think.
Sir is there, I think.
I am absolutely fine. I have been hearing it. Only thing I have switched over from mobile to the laptop since I have reached the room.
Yes, sir. Your views on the same.
See,
Yeah,
the question which
Eagerly waiting from Kerala.
absolutely, Thiruvananthapuram. The question is answered in a simple way. We need to look at the Companies Act officer in default definition. Irrespective of whatever be the requirement of law, we are concerned with the officer in default as defined under the Companies Act. In most of the penal clauses, you would have already read this and spoke about it. And the section 2 within brackets, this thing, 60, I'll just read it for your benefit. Only one subclause of that. See, every person, if there is a whole-time director, KMP and all, we know that. If there is nobody who is all directors, as may be specified, is also there by the board. So that clause 3, you please take a look at it. Clause 3 of the officer in default definition, such director or directors as specified by the board in this behalf and who has given his consent in writing to the board. Otherwise, only all directors if no director is so specified. So here the question which Amit has raised, if I am correct, is about whether the naming of a person alone is sufficient to leave others from being prosecuted. No, that is not so.
GNL 3 is mandatory.
That's what I'm saying. So if there is a provision by which you are trying to escape, if there is a whole-time director or KMP, it is not possible to come to terms with that. This is what I want to say.
So just one more supplemental question. I have been having this in my mind since quite a long time, and I had discussed otherwise also. For benefit of all, I am discussing it again. Generally, in criminal jurisprudence, when the concept of officer in default is applied, though officer in default concept simply means that by default, the guilt is being assumed against these people and these people are made accused. Whereas actually, only one of these officer in default may be held guilty later on in criminal jurisprudence. Let's say there are 4 executive directors, all will be made accused in the criminal prosecution, and later on maybe the order is passed only against one of the managing director on the proving that only he was guilty, rest all 3 were actually not responsible for that particular offense, right? Now, in case of compounding or particularly in case of adjudication, do we have any such option by which we will be able to prove it to satisfaction to the adjudicating officer or to the compounding authority that only X fellow was responsible, Y, Z was not responsible?
I have, you see, I have got sufficient experience of arguing these matters in both NCLT as well as before the compounding authority and adjudicating authority in the 2013 Act as well as 1956 Act. Under the 1956 Act, the regime was better and considerate. When it comes to NCLT, the maximum amount of fine and all, they calculate by number of days and amount. This becomes a very difficult task. You will not be able to rewrite the provisions of the law to remove liability. But that is why I wanted to speak on the prosecution generally, which I will probably take it up after the time arrives for that. You will have the power to apply under 463, which I have successfully used both under 633 era and 463 also. So we should be able to go there and ensure that we are able to get necessary relief for all the officers other than the person who has been specifically assigned with the compliance requirement of a particular provision. That will be the only solace I can say, relief I can say, which is possible.
But can this be argued in the case of compounding and adjudication also, is a limited question.
Argument is adjudication of penalties is an exercise where two things are adjudged. One is the contravention per se. Whether there is a contravention is an arguable point. You have all the right to use all your interpretation tools, factual matters, position of law and judicial precedents. Four things we have in our hand. Use all the weapons and argue that this is no offense. Secondly, once it is contravention is adjudged, then the penalty starts. That, of course, we have discussed several times, the fixed penalty, the leeway which is limited available to the authority and all. That's it. I don't know if we have already discussed about the certain prosecution related fundamental 435, 436, 439 and all. I will answer it whenever the opportunity comes.
Starting on that, sir.
Right, fine.
Ankit, we have to be very quick.
I will be quick. Prosecution is
Take Ravi,
not big.
and then I'll go to question answer.
So provisions of 4 section, as sir mentioned, 435, 436, 437, 38, 39, all deals with the prosecutions of offences under the Companies Act. So under 439, very clearly provides that all offences which are involving fraud, which are punishable under section 447, are cognizable offences, and all others are non-cognizable offences. So for non-cognizable offence, you need a warrant before arrest. For cognizable offence, you can arrest without a warrant. Or critical in offences which there is a degree of fraud involved in it are cognizable offence. So under the Companies Act, court can take cognizance of an offence in writing by the registrar, by a shareholder or a member of a company or a person authorized by the government. So special courts have been authorized under the Companies Act to try try for prosecution of offences committed under the Act, and for that application can be made by a registrar, company or person authorized by the central government. In case of issue or transfer of securities, in case of matter or offense related to issue of transfer of securities, the application can also be filed by SEBI. Special courts under section 435 has been established across country to take cognizance of all the offences under the Act, except offences related to wrongful withholding of property. This offence cannot be tried by a special court. Offences which are liable for which can be take cognizance by a special court are cognizable offence are 447, and these are the list of all the sections which have been identified as being liable for fraud under section 447. So where the complaint can be filed for prosecution of cognizable offence. The question is, since the section 439 allows you to file an application even by the company, so can a company file an application for an offence against any of its directors or officers in default under section 435 before a special court?
Yes, sir, this is a question to you or to Ravi.
Is this a question I didn't hear properly?
Oh, sir, section 439 provides that the court can take cognizance of an offence on an application filed by the company, member, registrar, and officer authorized by central government. So can a company file an application for offence against its own officer under section 439 before a special court?
No. 439 does not give that jurisdiction.
Though it provides court to take cognizance on an application filed by ROC, member, shareholder of a company.
There is a specific qualification or eligibility for filing criminal complaints. And there are cases where I have personally found 447, if you read carefully the definition of fraud, it involves an abuse of the position as a fraud. So certain occasions, the company may be probably as a juristic artificial person, but it has to go through the prosecutor only.
Yeah.
Where appeal can be filed against order of prosecution of cognizable offences.
No, it is the normal criminal code of criminal procedure. And a sessions judge, you are talking about a person of the rank of the sessions judge. And now, since the amendment of 435, they have included the magistrate court also as a special court for less than 2 years. If you read the clause, it takes 2 years or more. Unfortunately, the 2 years I found, it is not in sync with what is there in the CRPC. Probably they could have put 2 years down and more than 2 years up. And okay, that is a very, very finer and minor point. The idea is that it is the normal criminal courts having appellate jurisdictions which will handle the appeals, whether it is the magistrate's court or the sessions court.
But in case of fraud, sir, if, as you mentioned, if the fraud is one of the director is party to that fraud, and company wants to take an action against that person, so can it go to session court and file an application?
Company cannot do it.
Company cannot do it.
Not in special court, but other criminal CRPC can be invoked.
Yeah, we can.
Company as a shareholder, in some cases it is possible. See, nowadays shareholding is held by companies. So as a shareholder, if you are able to go, there is no issue. It is all about whether company on its own case against its own director or officer, there is a problem here.
435 cannot be invoked and 447 cannot be invoked by company itself. That's the
no. This is the same 1956 Act also. There is no difference in this.
Remedies available to accused in case prosecution is filed.
Yeah, that is what we need to be very careful at the provisions which we are looking at. For example, if you take 3 years imprisonment and above, because there is a summary trial procedure and all possible, 245 class action suit. If somebody is not complying with the orders of the tribunal, it is a very classic case of an offense for which the officer in default is liable to be punished with 3 years and fine, which means non-compoundable. What is the most worrying factor of Companies Act today is 212, subsection 6. 212 is not a penal provision. 212 is, after all, a fact-finding mission, a process to investigate and arrive at whether there are offences committed by and when and by whom. So it is the 4W and 1H 212 provision, that is who, when, why, when, and all, whatever you have to find out and how. So therefore, 212(6) is a very difficult provision. When you look at the provision 212, I'll just read for your benefit one language which is akin to the section 37 of the Narcotics Act. Yeah, 212 says
Shall I read it for you?
No, I have taken it. Actually, the Zoom to escape is not happening easily. Nothing more than that. I'm trying to go out of Zoom to refer to the Act. Yeah. Notwithstanding anything contained in the Code of Criminal Procedure, the offence covered under 447 of this Act shall be cognizable. Therefore, this is the most important provision. Otherwise, you know that all offences are non-cognizable under the Companies Act. No person accused of any offence under those sections. The only section is 447. Wherever 447 is referred, those sections have to be brought here. Shall be released on bail or on his own bond unless the public prosecutor has been given an opportunity to oppose the application, which is naturally done. The other point is and. The conjunction is and. Where the public prosecutor opposes the application, the court is satisfied. You see, at the time of application for bail, the court must be satisfied. There are reasonable grounds to believe that he is not guilty. The person applicant for bail is not guilty of such offense, and he is not likely to commit any offense while on bail. So this is a provision like the PMLA 45 or the Narcotics Act 37. which are the most draconian provisions we can say. And of course, in my book on this compounding, adjudication, prosecution, I have written exhaustively on the provisions of bail issue. And I very clearly remember there are at least 4 cases where even an auditor as an independent consultant to the company has been described in the complaint itself by SFIO as, you may be shocked, as a director of the company. For the simple reason that the promoters have inquired with the auditor how to structure the share capital of the company. And you say, I mean, next edition I will send you, that has come already. GP Madan ke liye to main bhej deta hu. So if you look at this particular the complaint, it describes the auditor who is an independent chartered accountant preparing some valuation project report and structuring the capital transaction with instruments like security, CCPS and whatnot. He has been described as the director because there has been a continuous correspondence for a particular period of time between the directors and the auditors, and they have fastened the liability on the auditor as a director, saying the director board is dancing according to your tunes. That is the kind of difficulties we face, and you now consider whether bail will be possible and how difficult the provisions are. Karnataka High Court granted after that. Of course, Supreme Court is seized of the matter. You know that there are several cases which are being considered. One such case which probably we can look at it, the Supreme Court's decision, Chandrachud decision in Union of India through Narcotics Control Bureau versus Nawaz Khan. This decision of 2021 may be considered. There are some more decisions which I have quoted, and the simple point is whether there is an opportunity given to the PP. Number one. Number two, is the magistrate satisfied in the beginning itself, basis the prima facie evidence available at the time of filing the complaint, whether the accused is likely to be accused and held guilty of the offense, and whether he is likely to commit. In all these cases, we have to show all these interpretation and all at that stage is very difficult. Our company law interpretation is not going to work. We are sure about it. So we should be very careful. You know, in 482 also we may not get a relief immediately. In these matters, 482 will come only if there is a long delay from the date of filing to the date of commencement of trial. 482 for quash also is difficult. 465, you know, Madras High Court recently said nothing doing for 465 in order to make a trial and inquiry. After investigation, a complaint has come. It is not possible to relieve the directors under 463 or 482 by quash or part quash or stay and all. So there has to be the one and only thing which we have to show is that the accused person accused of the particular offense, you have to show from the complaint itself, from the averments in the complaints itself, the documents enclosed, that there is no case which will prove him to be guilty of the offense. That particular point under 2126 is what is being considered under 45 of PMLA or 37 of Narcotics Act. If you are able to establish that, then the relief is available. All other interpretation, etc., is not going to serve any major purpose. So coming back to the Chandrachud decision, you have to remember the following facts, which following proposition, which are 1 or 2 items which they have said in these type of matters. The prosecutor must be given an opportunity. There must exist reasonable grounds to believe the person is not guilty of such offense and he is not likely to commit any offense. In this particular case, we have been able to show that the accused was only a chartered accountant, independent, not statutory auditor, but an independent, like company secretary in practice also tomorrow can be brought like this. Because we are day to day, we will be corresponding with the directors and officers of the company. Second thing is, these are all matters of evidence by records. Documentary evidence is always the superior to any other oral evidence. So therefore, basis this, we have to show this particular point that there are reasonable grounds, person is not guilty of the offense. That is exactly what is the language in 212. If you are able to overcome this, you don't worry about any prosecution under the Companies Act, because by and large, Amit Gupta and Badam, adjudication and compounding takes care of everything. That's all.
Okay.
Ankit, just to add.
Amit, no. Because we have a 38 questions that we have to reply. That is most important, and time is already overshoot. So I will start question directly. So some are the big questions. So I'm not asking these big questions, but I'm asking a smaller one first. With the time permit, then I will do. Okay. So for it, now we have divided topics to everybody. So if the question is adjudication, that person will give reply. If his question is different and anybody wants to add something, but very shortly. Okay, for adjudication, it is necessary to make the offense good.
Yes.
Okay. Is there a view that fine up to 25 lakh may also be compounded by the tribunal?
It can be.
Yes.
Okay. If company defaults in section 10A commencement of business, what is the penalty?
I think general penal provisions will be applicable.
Adjudicatable offense.
Okay. When a non-compliant
Nowadays, even name can be struck off.
Okay. When in non-compliance with regard to non-appointment of company secretary under old law, later continued to some period under section 203. Now, how this offense shall be regularized extending under two enactments?
I think it has been discussed that Madras High Court and the Ravi came out with a Supreme Court judgment. So let's say
465 is also there. 465 provides that all offences which have been committed under the old law will continue to be prosecuted as per those particular provisions.
Even if the decriminalization process has started.
Yeah,
That's what Ravi said. That's what Ravi said, that you can apply the judgment of the Supreme Court and you can always pray for mercy, and the new penal provision should be made.
But I think government should do something. So in one go, all these cases should shift to the penalty process. Anyway, if company defaults in section 10A commencement of business, then company shall be liable to penalty of 50,000 rupees. Our question is that can the penalty be reduced while hearing the matter by ROC?
I think same answer what we discussed at length.
Okay. This question is big. So what are generally the grounds on which the RD have reduced the amount of penalty on appeal?
It's basically a justification, and on the ground that company size has been small and the offense was not committed with any qualified intention. Now, these are the primarily ground on which the amount has been reduced.
Okay. In case of,
if you allow me, Pavanji, there are 9-10 bullets which can be made applicable whether in case of adjudication or in case of appeal or in case of compounding. Those factors have been given by NCLAT. One of them is gravity of offense.
Okay.
Another is whether the act is intentional or unintentional. Third is the maximum punishment prescribed for such offense, such as fine or imprisonment or both fine or imprisonment. Fourth is report of the registrar of companies. Next, period of default.
Okay.
Next is whether petition for compounding is suo motu before or after notice from ROC. So that makes a whole difference.
Okay.
Whether a default has been made good or not. What is the financial condition of the company and other defaulters? That should also be considered. Whether an offense is continuous or it's one time. Whether similar offense was committed earlier or not. Whether it means the person is habitual offender or not. And whether the act of default is prejudicial to the interest of the members of the company or public interest or not. And another is whether there has been any wrongful gain or some loss to others or not. These factors must be considered by the adjudicating authority as well as by the tribunal or even by the appellate tribunal.
Okay. In case of OPC, which has not filed annual return on the financial statement for last year, and auditor has filed ADT 3 stating that he is resigning and has not audited financial statement for last 2 years. What can be done?
No, you
No
have to
adjudication.
regularize it, get an auditor appointed, regularize, get the audit accounts audited, and then file the balance sheet.
Anyway, this is separate question, so I'm not just focusing. A company has not filed the financials since last 10 years, and due to change, it has now strike off by ROC. Can such company be active by filing its financial without any further penalty by ROC?
No, I don't think
So
there
all
is.
it has to be restored, and after
Then-
restoration, all the previous filings will be required to be completed, and the penal consequences may follow separately.
Okay. My query is that while filing an appeal to RD against the adjudication order, the amount of penalty as imposed by the adjudication order has to be mandatory deposit with the government, or filing the appeal inherently stay the adjudication order. Because most of the order mentioned that the penalty shall be deposited within 90 days of the order, and it's quite difficult to get the appeal order within 90 days from the adjudication order. Practical problem.
So there are two type of practices which are going on. There are a couple of regional directors who insist for deposit of that particular amount, but by and large, you are not required. Once you have filed the appeal, then you are not required to deposit. But while RD is passing the order, they passes the order in a manner that whatever amount RD has prescribed has been deposited and the chapter has been closed. In majority of the cases, that type of order are passed.
And for appeal, you have
To add-
60 days. File for payment, you have 90 days. So you have time before
I
payment.
wish to add something here, just a little change in what Sir has said. See, the adjudication order would not get stayed automatically by filing of the appeal. The grounds of stay and the provision of stay is given in the Income Tax Act, followed in the SEBI regime as well. And I think an interim stay application should be made along with the appeal for achieving that purpose, else the adjudicating officer would be well within its rights to recover the penalty. Because the rule says that order is not bad or stayed unless it is stayed by the higher authority. That's the rule.
Yeah, that is right. You are right. Okay, can
Pavanji, what Amit is saying, that there is no uniformity of practices, or there is no SOP issued by the Ministry of Corporate Affairs to its own regional directors. I think that should be there. That's
That is one question which I'm coming again. Can NCLT adjudicate compounding matter where compounding fees is less than 25 lakh, or is there any discretion on NCLT bench to seek back application to RD for adjudication?
There is an NCLAT order on
No,
this.
this has been answered. No, this
Yeah.
question was answered specifically.
Okay.
There is an NCLAT order, what Ankit was mentioned. So there is no ambiguity. Even if amount is less than 25 lakh, NCLT has the power to compound the offense.
Okay.
But generally, sir, ROC, once you file an application and the amount is less than 25 lakhs, ROC will never forward that application to NCLT. He will always forward it to the RD.
There have been cases where the application has been filed directly with NCLT and NCLT has entertained.
Okay.
You know, the question is whether NCLT can remand back the matter to RD. That is what the question is.
Generally, we have not seen NCLT.
No, it's not, but NCLT can.
Yes.
NCLT can.
But they generally come back.
Okay. What happened to the prosecution filed under Section 1956 Act not yet taken up for the court pending the trial?
I think if I can say so, Ministry is in the process of getting all these old pending matters settled and closed as per the information available. But till the time any formal guidance or order comes, they will continue to be before the court of law.
Okay.
But prosecution already commenced, prosecution not commenced. That is the line, dividing line. Prosecution already commenced. It will take its own course. Prosecution not commenced. It is not possible. That's all.
Unless Ministry withdraws.
History withdrawing is something different. Question is, can you now file a complaint against an offence committed under the 1956 Act? For example, 212 similar investigation was there in 1956 Act. It fructifies today into a final report and discovered offences are discovered for prosecution. So we should remember only one aspect we should remember. There must be proceedings continuing, prosecution launched. Suddenly you cannot today come back and file an offence under 1956 Act at all. It's gone once and for all.
Section 468 of CRPC provides for limitation to the point Dr. Ravichandra is mentioning. And you can't file. There is a specific limitation under criminal law as well. You can't file unless until you prove that the time was consumed in investigating or there is a deep-rooted conspiracy or fraud that you could unearth only after detailed investigation.
Yeah,
That is the
465 if it applies the effect of repeal. Otherwise, it is impossible.
Yes.
Okay. We could not bring subscription money within 180 days from the subscriber residing out of India. Now we want to bring the same and also want to file INC 20A and also want to ratify default by adjudicating process. Can we do so? Can we do suo motu?
Yes, you can.
Okay. We would not file NDH 4 within 1 year from the date of incorporation of the company. Now we want to ratify the default. So it is possible for by adjudicating process.
Sir, NDH is altogether a different domain. I think ministry has taken altogether a very different stand on the same, and whether your company will get the license of Nidhi company by doing so or not is a very tough question. No NDH form, NDH 4 has been approved so far, and they are all pending. So we can't advise what ministry view would be in this particular case. Whether by doing so, suo motu, whether it will be compounded or not, whether it will be adjudicated or not, whether you will ultimately get a Nidhi license or not is a very tough question. Means unless ministry takes a stand.
Okay, ROC through routine exercise of powers conferred under section 248 strike of names of the company on the ground that the company has not been carrying out any business or operation for a period of 2 years. In several instances, the companies are in fact active, carrying out business, have assets, making profits. These companies have then to approach NCLT or NCLT on appeal requesting for restoration name of company. Don't you think there is a need for more checks at ROC level before the strike of the name of the functional company? Pradhan sir?
But in such case, if the company is working, making profit, though there is a case, but why they were not doing the filings?
It means that no filing is there. Show cause notice is issued. That has not been replied to. Why are you asking more checks at the level of the ROC? Why not more and more checks at the level of the company
So
concerned?
simple is whatever you are doing, if you are not informing, then you are a strike off. This is a simple point.
But again, before striking on, you receive a notice. You get an opportunity to respond to that.
Okay. As a professional, we have taken the government regarding penalties they leviable on MSME. Certainly, it should be 50% the amount levied on the other companies. Otherwise, it will be negative impact on growth of MSME. Okay, that's just some suggestion.
Which is already there for 446B, what Ankit was mentioning. In case of one person, small company, producer company, startup, the amount of penalty is 50% only, and the upper cap is also there. For company, it is 2 lakh, and for individual, it is 1 lakh.
No,
Okay.
but the question is whether all MSMEs are small companies.
Okay.
No.
I mean, you have
The
mentioned
question is, because this question is MSME should be covered by this provision. Whether
The
all
majority of
MSMEs
them,
are small-
I think a good number of them will fall.
Amit, you have mentioned some judgment. So Saurabh Agarwal is asking, so you please share the judgment name.
We will share. We will share.
Okay, a company has got to CEO, CFO, SCS, MD. The company has conducted AGM blatantly and wants to file for suo motu compounding. Who will be the considered officer in default?
All of them.
Okay. For a different view. Now, very, very interesting question from Yamadan. You want to say?
No, I'm with Ankit.
Okay. Now, very interesting question and from a very interesting person. Is that ROCs are following different procedure while dealing the adjudication of offences? If it is so, that is what is the correct procedure to be followed by regulator vis-a-vis professional? My answer is yes, the ROCs are following different procedure because there is no clear-cut SOP. The government should bring out the clear-cut SOP communicating to the all professional and the ROCs also, and whatever things are there, they should regularly modify it on the basis of 6 months or 3 months, so that can be there. And my view is anybody has a different.
These questions should not be answered here. Either one-to-one basis.
No, okay. That's okay.
But rules are there. Rules of procedure are there. It is not being followed scrupulously.
Somebody is saying if the offense is repeated, fine should be double.
It is already there.
Yeah.
It's already there for some places.
Share application for equity accepted, but no share were issued and company showing it is an unsecured loan. What is the process to take up for the complaint?
If
Is
it
it a
is
subscription money?
No, equity accepted, but no share were issued and company showing it as an unsecured loan. That's it.
then no, so but if it's an unsecured loan, then it's not a
What
subscription
is the
money.
process to be taken up for the complaint? I think somebody is saying you can make complaint if somebody is doing this. Okay, suo motu is done where there is a possibility of due diligence done before investment. There's somebody is commenting on somebody's question. Can penalty based on parallel of LSF under FEMA?
So there under FEMA, why for LSF they have specified different criteria or formulas for the purpose of determining the LSF. But the Companies Act, there are specific amounts, no specific formula is prescribed. So there is a basic difference, though they can definitely consider some way of determining or adjudicating the penal amount.
Okay.
A lot of discretion has now gone in case of RBI compoundings.
Okay. How's the penalty fine calculated if some of the offense for multiple years are clubbed and filed as a single compounding application?
Sir, if it's a continuing for each year, then for offense for it will be counted for each year separately, and then you aggregate it.
Each year, each director.
Yes.
Okay. Yeah, Madan.
You know, in case of this Pauja Taki seed, I think Ankit also referred to that. The technical member had a different view. What is it?
Hello.
Yeah.
That is gone. Why we discuss that?
Okay. Anyway, okay.
That will take a lot of time.
Okay. Well, so Ravichandran has given the right, correct answer to. Yeah. What is the penalty for violating under section 185 and use fund for director for personal use without disclosure in report by auditor? Auditor is also liable for such a non-disclosure.
Penalty, I think company can take an action under 452 for withholding of property without the improper withholding of property and auditor. So it must be a non-compliance of CARO or any other thing. So the relevant provisions will apply.
Any other view? Okay. If KMP is there, then we cannot file form GNL 3. All KMPs are officer in default.
We can still file GNL 3.
Still you can file.
Okay, some same case is happening under section 173. CS is making liable for non-issues of notice.
Possible.
Okay, can offense liable for adjudication be compounded suo motu?
No, adjudication can only be adjudicated.
These two are totally different as of now.
Okay, how section Ravi? How section 463 can be invoked in case of compounding?
I will answer that. The court has no restriction with respect to granting of relief. It is in all cases, whether it is compoundable or subject to adjudication of penalty or any other reason, relief is 463 available. And in fact, Madras High Court, current Supreme Court sitting judge, Justice VRSJ, that is V. Ramasubramanian, in Visram financial case, went ahead in laying down the proposition that even after prosecution, the High Court has power under 463. This was based on former CJ Sadasivan's earlier ruling. And in Visram Financial, they came back and said relief can be granted even after the prosecution. The question which Mr. Narayanan or somebody has raised is, he wants to know whether relief can be granted under 463 when there is only the adjudication of penalty or compounding. I say yes, for all the kinds of difficulties under Companies Act, I have invoked 463 even for disqualification removal.
Okay. Cases filed by ROC Magistrate Court under section Companies Act 1956, which pending can be settled through Lok Adalat. Is it compoundable offense also?
Yes, I don't think there is Lok Adalat, how it will come for prosecution criminal matters, sir.
Okay. Okay. If the stock exchange levy fine for late filing of document, is there any scope for appeal?
Yes, there is always a scope.
SAT.
Even in the stock exchanges, there is a mechanism you can make an appeal where they give you an opportunity of being heard.
Ravi,
And
you have any view on this?
No, we have filed appeal in SAT.
Okay. No, I'm asking Ravi Prakash, you have any view?
The Lok Adalat question, sir?
If the stock exchange levy fine for late filing of document, is there any scope for appeal?
Yes, SAT, you can approach SAT. That is provided in the SCRA.
There are two ways. One, you can make a application for waiver with the stock exchange itself. Second, you can file an appeal before the SAT.
Okay. Can a GNL3 can be filed for past years also?
No, but how you can do it today? Question is that if it is only delay, if you have already appointed a person and he has given a consent, if it is only delay, then certainly with the payment of additional fees, it can be filed. If it is only delay on filing, if you have already nominated a person, how you can nominate a person in the past for the offences for the period which has already passed? It can be only prospective.
Okay. Okay, now there are 2-3 big questions. So I'm just asking, that question is good. So that's why I'm asking. Can following section will be elaborated? Section 99, punishment for default in compliance with provision of section 96 to 98. If any default is made, holding a meeting of the company in accordance with the section 96 or 97 or 98 in complying with any direction of the tribunal, the company and every officer of company who is in default shall be punishable with fine which may extend to 1 lakh rupees, and in case of the continuing of default with the further fine which may extend to 5,000 rupees for every day during which such default continue. Minimum fine which shall be less than 1 lakh. It means the RD can impose minimum fine that shall be less than 1 lakh. Is it correct interpretation?
Yes, it is possible.
You know,
So the essence question is that this is the provision that you have read is section 99. If I have not holded the AGM in the due period of time, then section 99 gets invoked. And if you file the application for compounding, then question is whether RD can levy a amount of compounding cost less than as is prescribed in the section 99 as a minimum fine. Answer is yes.
Okay.
Although I think there is one judgment of NCLAT. There are 3 judgments in series, if I remember very correctly. Earlier, it was not possible. Then I think VRV solution was one judgment where NCLAT has held it is possible. Then it was overruled. And the latest judgment is again contrary, which says it is not possible. However, we have seen that in practice, NCLTs and the RDs have been levying the cost, which is much less than the amount which is prescribed in the respective section.
Okay. Okay. If default under section 197, 134 happened in the one private limited company in 2016-17, thereafter entire board has changed. Management has ownership and board has changed. In 2020, new management filed adjudication and then paid the amount, but old management has not paid. Old directors, they have not opportunity, they have not paid. What is the solution?
So in respect of, see, adjudication is always like you are going to the regulator and to the adjudicating authority, admitting that you have committed an offense. So whosoever is the current board, he is admitting that yes, the offense continues and we are ready to pay the amount of penalty, whatever is leviable. And company and the current director has paid whatever is in respect of the old management. I think that offense continues in respect of those people. And the ROC will be in its power to levy any amount of penalty tomorrow on those respective board of directors.
Okay, last
With respect to Pawan,
yeah,
I just will add one point here. 32A of the Insolvency and Bankruptcy Code provides for an escape for the corporate debtor. In terms, that is one exception. Therefore, I thought I will mention it. Secondly, officers of those times are liable, and the company will anyway continue to be liable. That's all.
okay. Last question. Recently, disclosure and financial statement are enhanced, but company followed previous contents only. Auditor did not qualify. If ROC issue noticed on insufficient disclosure, can the company take a stand that as the auditor did not highlight nor qualify. It is board's assumed correct disclosure.
No,
I
I
think
think
They cannot.
Yes,
that cannot be
not escape. Both will be guilty, auditor also as well as the board. Okay. Now, friends, we have tried to give all answer which we have received. Okay. Now, there is because we have to close this. We have already exceeded the time. Now, I will start as ritual that all these things have changed. So many things they have changed in New Companies Act. But still there are some things as to like SOP, different practices followed by the RD and ROC has to be changed. The online adjudication process, which is mechanical, should start. So the burden on these people should be reduced. So something new has to take place. So I'll just start with Ankit. What is your view on this? What are the changes government should do? So when we'll compile, we'll send it to them.
I think the e-adjudication is already in the pipelines. If that can be done, a lot of relief can be there. And simplifying the process, I think still the compounding process itself is too big. We have to file to ROC then forward this to RD, then there is a report that is sent. It consumes a lot of time. A similar process in this case of RD adjudication also. Standardizing the process, reducing the timeline, and trying to automate as much as possible.
Okay, Amit.
I think we are already on the right track as we have moved from the criminality to civil offense regime, where of course, the level of vigilance on the non-compliance is very fast. So I think the lesson and the message for the corporate is that regime has gone where we continue to avail the luxury of non-compliance for years without any prosecution. I think now we can't afford, so we have to change the gears and we have to make our corporate compliance team uphill on the task that we ensure zero tolerance. Government is doing, I think, perfectly all right. Whatever rationalization and implementation is required to be done, standardization should continue. I think we are good.
So you're calling upon me?
I'm just asking your view.
Yes, sir. So the prosecution should not be mindlessly inflicted, and something on which there is a gap internally. Those issues they should seriously consider to clarify, because something on which difference of interpretation appears internally amongst them is certainly a contentious issue for professionals and as well as the public and stakeholders. So these are the two things. Third is that automation should not result into mechanical action. They should understand the duty, because if they throw someone before the court, it is a matter of reputation. It puts an indelible blot on them. So therefore, this should not be done. They should at least follow their own procedure, their own laws, own words, at least that. You are on mute.
Sir, you are on mute.
I'm saying mechanical violation can be done because everything we can do it. So by this process, people may do mistakes. They go over to do the compounding and come back. Yeah, I'm done.
No, I think just a small point. I think what Ravi is trying to say is while there is a good use of technology, always good, but there should be some mechanism by which you can ensure that the person who is not guilty should not be unnecessarily be penalized because of the mechanical follow up the process. That's the message I think Ravi wanted to convey.
Okay, Madan sir.
Change of mindset. Judicious use of the term mens rea. Not to treat every non-compliance as offense, civil or criminal. And wherever the judicial procedure has to be adopted, should be adopted. This digitization cannot take over the judicial mindset.
Okay. Ravi, last point. Last word, I think.
KSR, KS Ravi, you know, you're two Ravis.
Okay, KSR.
Okay, that's why I waited. Thank you.
There
are only three points I want to tell. See, 42, if you read 42, the provision says if company defaults, that is subsection 9, the company, its promoters and directors shall be liable to a penalty for each default. Like that it goes. And it is one of the provisions where the subsection 10 is more serious than 9. It takes company, its promoters and directors shall be liable to a penalty which may extend to the amount raised through private placement or 2 crore rupees, whichever is lower. So in one of the cases, company law tribunal was arguing with me, I can say ulta, that each one has to pay. In that case, there was company and promoters and directors, totally about 6 people, and 12 crore was what they were indicating to me that they will impose. Then I escaped some other way that I will tell later on separately. The point is, that is one provision where clarity is to be achieved, number one. Number two, I feel it is time for merging this 441 and 454. Make everything compoundable, even if it is subject to adjudication of penalty. Make the life simple. Make suo motu application. Let the judicial decision of NCLT, like Chandigarh bench decided, they have the discretion. They should continue to have the discretion to levy even 0 fine. Let off, like SEBI has let off recently in some matters. So we should have that kind of court system, judicial brain, judicial mind to relieve officers subject to facts and circumstances like 446A. What are the mitigating factors, or what Madan has described in NCLT decision, so many additional points. So that judicial thing is required. Therefore, merge this 441 and 454 is the second suggestion. Third is the prosecution as such is a very difficult proposition unless the fraud is established. Therefore, I think the only element in whole of Companies Act should be 212 induced 447. That's all. That's all. 3 points. Finished.
Nicely covered, Ravi. So, friends, thank you very much. We have already exceeded 27 minutes, but people are there. Still, they were asking questions. So I thank everybody. Ankit, Amit, Ravi. Ravi, despite on holiday, he has attended. Madan sir and Ravi Prakash. So thank you very much. Thank that we have given answer also of all the queries, and we have given we have discussed in detail. Just a minute. Sorry. So friends, our journey of this knowledge sharing will continue. Now, as you are aware that first Friday of every month, we are doing updation of the last month. So whatever updation up to 6 from the last Friday of first Friday of the last month, December, we will discuss each and every point, and so many changes have come. So we all will discuss. So see you on 4 p.m.
Sir, I have a small suggestion, because this will be the yearly roundup also this
Okay.
Next Friday. Can we do, because there are a lot of people who miss out a lot of updates, though there are regular people who are watching. Can we have a yearly update also of a important, maybe 10 important updates from each respective area, so that people are not just missing out along with this particular session?
So Amit, वैसे लोग पढ़ते नहीं है, और you want to make them that whole year they should not read and they should come. Okay, we'll just try to work out that how we can do the wrap up. So 6 January, Friday in the new year, we will meet again. So thank you very much all, and Happy New Year in advance to everybody. And I hope that this new year will bring prosperity to all the professionals, all the corporates, and India especially. Thank you very much.
Thank you, sir.
Thank you.